So welcome, Lauren, and welcome everyone to the webinar. Just a quick reminder to everyone that feel free to use the chat function if you have any comments to make. People are introducing themselves in the chat box. And then if you do want to ask a question, please use the Q&A function, and then myself will read those questions out to Lauren and he can respond to them. So with that, I will pass things over to Lauren.
Well, good morning. Thank you, Sherry, and thank you to yourself and to Alberta Wheat for providing leadership and putting this seminar together. Today, I just want to briefly describe some changes that are relatively new and just talk about some of the issues around plant breeders' rights and how it changes slightly what happens in the research setting. And really keep in mind that part of the education that we do in Seeds Canada in this area is we're trying to avoid disputes. The goal is to actually avoid that. So let's just see if I can make, I don't know what, oh, there we go. So our focus in intellectual property is really around three areas. We are strong believers in education, and we spend a lot of time on that. And really because in agriculture, most people will support what we call the rules if they know about them. And in our experience, sometimes we run into problems because people didn't know what the rules are. Secondly, we perform a function for the industry and distributors where we actually collect concerns. Now, this is not about trying to find and work with people in a negative way. This is more about trying to find people who may not understand the issues and work with them. And that's 90% of what we do now, is getting on the phone with farmers or getting through email and simply say, this is the rules. Do you know? And how do you adjust? And finally, in a small portion of it, we actually have to go in and take what would be known as enforcement action. And that varies from really minor things like letters and phone calls right up to and including assisting our members in filing civil lawsuits. Although we're going to talk a lot about plant breeders' rights, I also want to make sure that you understand that in the seed business in Canada, there are actually three primary tools of intellectual property enforcement. The first is plant breeders' rights, by far and away the most used for protecting varieties. The second is contract law, and it's completely appropriate to use contract law for any variety in Canada on its own or in conjunction with another right. And finally, there is some work in patents. Patents have traditionally been used not for varieties, but for traits. But there is some indication that some people have been successful in using them in the variety sector. Now, in 2015, Canada upgraded our legislation to what is known as UPOV 91. UPOV is an international treaty designed by the plant industry for the plant industry. And it goes back many, many years. Canada was party to the discussions back in the 60s. We first put our first PBR legislation in place in the 90s. Actually, we put our legislation in place in the 90s within months of the international treaty being upgraded to a new standard. So that's where we're at, 2015. One of the things that we have to remind people is the group of rights that were there prior to 2015 can no longer be accessed. You can only get them update rights. So really the plant breeder's right is the right of the person who, or persons who developed a new variety. In the newest version, what it does is it's a more complete set of rights. It allows the breeder to determine a whole bunch of things about how his variety is used. And there's key things that plant breeders' rights allows that are an expansion. It allows, in its present form, buyers and sellers are both responsible to adhere to the right. It means that things like conditioning or stocking for an illegitimate sale is also a violation. It also clearly says the importing of seed that's protected and the exporting of seed that's protected are also controlled by the breeder. So it is significant in its expansion, but its impact on the producer and the research community is much less than its impact on some of the other players. One of the other parts of plant breeders' rights that's misunderstood is it is completely enforced in civil courts. That's the tradition in Canada. Intellectual property rights are always enforced in civil courts. There is limited examples where there is a regulatory requirement. They're all done civilly. The top side of this is it allows people to do some things that are more flexible. The bottom side is it becomes really, really expensive for everyone if there's a dispute. And that's one of the reasons why, as Seeds Canada, we have chosen to spend more of our time on education and monitoring. That's where the majority of our focus is. Understand that if you're in breach of a plant breeder's right and the plant breeder is able to prove that to the satisfaction of a civil court, they are entitled to damages. And damages for a layman, basically, this is a form of lost royalty or lost profit. In the most recent cases, the standard is if someone takes my variety and sells it, and I lose $1,000 worth of margin or $1,000 worth of royalty, the court will award 3 times that amount as a penalty. And the reason they do that is so that it clearly shows to the person on the what we would call the infringing side that the court doesn't support their activities. So it's not a value judgment in any way other than to say, we want to make sure this is tough enough that you never do it again. That is the rarity. Most of the time, this is a conversation where we simply are able to convince people on the wrong side not to take the actions. So the PBR 78, which is what we had until 2015, to PBR 91. And this is really, really important that we understand that there are still varieties with the little symbol that says PBR 78 at the top in the marketplace. And there are those that are PBR 91. And the industry took a leadership role in establishing those trademarks so that these 4 main points were clear. So the first one I've already talked about is the extension of the right. The second one, for agricultural crops, there's a small increase in the time of protection. And then we're going to talk about farmers' privilege. Now, one of the mistakes that happens in popular culture in Canada is to talk about a farmer's right. In fact, the Supreme Court has already ruled that does not exist. In the Canadian context, we clarified after consultation with producer groups that a farmer's privilege is in the legislation. But the challenge with the farmer's privilege that people don't understand is you must have a qualifying purchase to get the privilege. In other words, you must have paid at least once for the variety you have, and that payment must have gone to the breeder. So it's a little bit different. It covers all the things that are necessary for farm safe seed. The farmer's privilege allows a farmer to purchase certified seed and do everything he needs to do to use it on his own farm. However, it can be restricted by contract, and that's something we can talk about. There's also the opportunity for someone as a breeder to go into the grain handling market and simply say, I think that this product, this grain, has been acquired illegally. In other words, farmer X had it, he sold it to grain company Y, and we can't see any justification that farmer X actually bought it legally. Now in Canada, then the traditional way of bought it legally means, did you buy certified of that variety at some point? This is quite an interesting extension, but it's actually something that is in place in many areas around the world. And again, a lot about education. We have spent time with other sectors. Early on in 2016 and 17, we provided recommendations how they could stay on side. We've talked to the grain industry numerous times. We've talked to the seed processing industry. And so now we're talking to you, and partly because there was lots of issues in the grain handling industry when this came up. Excuse me. A little more depth into a farmer's privilege, because it does impact how you deal with your collaborators and your cooperators. A farmer's privilege is triggered, and when there's an actual purchase of pedigreed seed. There's no backdoor method to getting it. You actually have to be able to prove that you purchased seed from an authorized seller. The simple way in Canada, of course, is simply the purchase of certified seed. Certified seed can't be sold to you unless the person selling it has actually got authorization. It must be legal. It can be restricted by contract. And the way that it's worked in terms of support is everybody in the value chain is responsible to make sure this happens. So there can't be transactions that are to frustrate this. It has to be something that works. So let's talk about research and understand that Plant Breeders' Rights is a supporter of research. The goal of a Plant Breeders' Rights legislation is to provide a framework that allows the distributor breeder to be paid for their innovation. Under UPOV 91, the exemption for further research is still there. If you're researching a variety, if you're using it for further breeding, if you're using it for agronomic research, that's allowed. There is two parts to this that we should be confident in. Number one is the recommendation is that there still be a form of a material transfer agreement that has less to do with plant breeders' rights and more to do with some other international obligations of Canada. Canada, under some other international treaties, is committed to knowing where varieties come from. And most specifically, it's under, of course, I can't remember the name of it right now, the treaty that has to do with whether or not there are parts of a variety that were acquired from the natural world. I mean, if you went to Syria and picked a wild barley and used it in your breeding program, we are committed by international treaty now to keep track of that particular genetic makeup through our breeding program. And most organizations have some form of a material transfer agreement. The second thing is there's a new concept in plant breeders' rights that we talk about, and that's called essential derivation. And it's in its simplest form. It says, if I have a variety that I've developed and someone comes along, John, and takes my variety and makes a very minor change to that variety, and he puts it on the market, and it's essentially derived in all its characteristics to mine, there may be a responsibility that John has to pay the first breeder. Now, this is new, relatively new. It's only been in discussion internationally for about 20 years. It's relatively new because it's the first time it's been involved in Canada. And essentially what it says is there has to be dependency. So if John couldn't develop his variety without using mine, it's dependent on mine. It's an extremely, as I said, it's relatively new. It's specifically there because there was concern that valuable traits to the farmer would be put into existing varieties, and then that would erase the PBR of the existing variety too quickly. That's why it was put there. There's a lot of work to do. We haven't educated enough on this in Canada on its impact, but it is those two reasons that I just spoke about. One is the Canada's responsibility to ensure that we knew who the genetics are that we've got and whether they came from a traditional source or a landrace source, and two, being able to track whether something is essentially derived, are fundamental to the idea that you should have material transfer agreements when you're bringing in product from outside your breeding program. And there's limited reason why that should happen. Now, if the setting that you're talking about, if there is no breeding going on at these sites and there's no taking of that material for breeding, we can use other methods, but there still has to be some kind of a tracking system. So that's what gets us to the discussion today. And let's start with the first principle that I talked about. We think your collaborators need to know. We think the people that you are supplying seed to, whether that's for a regional variety trial or whatever it is, need to know that the varieties they're getting are covered by PBR. In the case of anything that's a 1991 variety, it is simply not legal for you to transfer to them product for them to continue to grow the harvest material on their farms. That's just, unless there's an actual sale that's authorized by the breeder, it's just not appropriate. I'm not a lawyer. I spend too much time with lawyers because they like to talk in very complex language. But we really encourage whatever agreement you have with your collaborators to be in plain English. As plain English as you can make it. It has to be somewhat detailed and clear, but plain English. And simply put, you can't acquire a farmer's privilege by doing a research trial and harvesting the material, harvesting the grain and using it yourself. One of the things we also do in all of these recommendations, and we have a series of them, there's a site called pbrfacts.ca where we lay out recommendations for other sectors within the industry. Simply, there should be a declaration in place that says that the cooperator understands the rules. And in the case that is most concerning is they have to understand that the harvested material that comes off of those trials cannot be retained by them and grown for seed because it is simply not a legal sale. So that's part of it. These are the last three are Lauren's experience. Things that are written down are never remembered consistently by the two sides. And it becomes he said approach. So we're in favor of even brief written documents of some type that both sides have said, yeah, this is the general agreement. Now, in a commercial sense, one of the things that's happened to us many times is when we do get into a dispute that we can't resolve without going to court. As Sherry said, I've been around the industry a long time, and I've been at the front line. I've supervised frontline workers, both in terms of seed sales and grain handling. I've been involved in consulting for a number of years. Without exception, every time we've got into a serious dispute, at some point, some frontline person comes to me and said, I knew we shouldn't have been doing this. I got a bad feeling. The person on the other side just gave me the willies, or whatever you want to call it. I can't think of a case that we've had, and we've been involved in, we've actually been involved in over 100 lawsuits I can't think of any case where somebody said, I knew this was that guy was going to do this, or that person was going to do it. So if any time you feel like the person on the other side isn't prepared to live up to the whatever you're asking in writing, or they're resisting writing it, pay attention, because those are the ones that come back and require legal work. Without exception, they're going to be the ones that you have a problem with. Don't ignore your gut feeling. And frankly, it doesn't have to be someone that's been in the industry a long time. We have a case where it was actually a summer student that actually owned up to the fact that the day he dropped off some seed at a grower's place, he knew there was a problem. He could tell just from the attitude. The other thing is, if you have an issue, ask for assistance early. Don't wait until something has really gone off the rails, and you ask as quickly as you can. And educational seminars like this are part of it, but ask for assistance early. The earlier we can get involved as coaches, and that's what Seeds Canada is, we coach people that own the rights or people in the industry to stay on side. The earlier we can do the coaching, the more likely we can resolve it without undue cost or dislocation. In my years, decades of work, the number of farmers that object strenuously to these rules is actually a very small amount. When you describe to them that they're actually paying for the use of seed to reward the breeding institution or the breeder or the developer, generally there's not a problem. There are some that do for different reasons. There are some that are difficult, but they are the minority. And I mean, our records show that 90+% farmers support paying for innovations that they receive. So a draft cooperators agreement, and this is something that we talked about last spring, and then I just sat down the other day and said, what would be the most simple thing to do for a field trial coordinator, a cooperator, pardon me. And this is 4 things. One is transfer, sell, or distribute seed or grain to any third party. Just, that's it. They could sell the grain for grain use or feed use, but they can't sell it for seed use. Secondly is to take what was harvested off a field trial. You know, there's a best variety that they saw in their field trial, and they save that seed and then they use it themselves. The seed supplied to them for research trials is for a single crop. It is for the research crop that they're growing that day or that year. And the harvested material off that trial is not to be used for seed. A little bit of a different thing here is many times you guys are very good at what you do, and sometimes you supply more seed than is needed. They can't take the extra seed that was grown outside the trial and propagate it either. Whatever's been supplied to them. And this is actually a real life example where someone took some seed that had been supplied to them. They used X amount for the trial, and they took the extra and put it in a different field and started increasing seed for themselves. That is clearly a violation of PBR. It wasn't authorized. And finally, although this is very rare, if you plan, or if your cooperator plans on using the varieties supplied to them in a breeding program, they should have a material transfer agreement. Now, again, it's very rare. Most institutions have a standard MTA that's used, and most of them would understand this, but it really is part of it. Just as a note, this is extremely important to all breeding institutions. Not that they have MTAs, but that everywhere outside of their organization they supply seed to has an MTA with them. And it's important because we need to know, from the breeding books and from the records where things come from for a number of different reasons. So We're in the business of coaching. Sorry, my cat just decided he was going to fall off the window into the wine rack. We're in the business of coaching. We don't have, as Seeds Canada, any authority. The authority rests with individual breeders. Our job is to educate and coach, and sometimes it takes a little while to work through exactly what happened and where the impacts are. But we're always open to do that. It is part of Seeds Canada service to the industry. So we're available, and I say we're because beyond myself, there are others with some experience here, and we hope in the future that there'll be a couple more. And one of the things we know is sometimes our regulatory process in various ways isn't always in agreement. And sometimes it takes a little while to figure out where it is. But in IPR, it's pretty simple. The person that developed the variety and got a PBR right is in control of how it's used. And that's what these rules do. So not a very long presentation today. I want to just close by saying that in the number of years that we've been doing this, myself and also many of the senior people that are involved in many of these seed companies, we've learned some things, and these are really around that. We try to describe the right exactly the same way, regardless of the portion of the sector. We have specific examples that we do. We've come to call it do right recommendations. Instead of talking about what's going wrong, we make recommendations on how it's done right. I have many stories and experiences around being appropriate. And I think understand that the companies now, treat a farmer with a few bushels of seed they're selling to a neighbor totally different than they treat a company or an individual that's set out to make a business of breaching PBR. So those are two different examples, and they're dealt with two different ways. We supply trademarks, as you saw. We also have a number of databases that allow for information. And again, we supply coaching. So that's what we do. There's a set of recommendations we ask our Seed Canada members to do. And I should tell you that the majority of our education starts with educating those in the industry. So we talk, or I talk, or others talk to, the reps that are in each company. I've done multiple webinars on PBR that were solely for company staff. We talk to them, we educate them, we provide information, and we ask them to be upfront about what's involved. It is our expectation that a Seeds Canada member employee will never misrepresent the PBR status of a variety. It is an expectation that when a variety is protected and a farmer says, is this protected, the employee will represent correctly what's protected. And again, there are times at which every one of us has those experiences where something doesn't feel right. That's when you pick up the phone and describe the situation. Inside Seeds Canada, all of our reports are held strictly confidential to a very small group of people. We have a full-blown organizational structure that allows us to keep all questions about specific example-based enforcement strictly confidential, and a code of impartiality. So there are times when we do get reports of things that aren't violations, and we have to tell the person who has raised the complaint that that is not a violation. We treat them exactly the same whether they are or aren't. We deal with the issues, we get the facts, we make a recommendation. As I said, we have lots of things to help you with. This is part of the PBR Facts website. We have tools that include recommendations, the more description about what's going on, and it's part of this whole education and outright about PBR. This is another tool that's available. We also have some PowerPoints that are available. I just remind you that as Seeds Canada moves in, there's some branding work we have to do, because many of these presentations were either branded as CSTA or CPTA, two organizations that are no longer active. Thank you for your time. I hope I helped open the discussion. I'd be pleased to answer any questions and concerns that you have.
Thank you, Lauren, for that very informative presentation. And maybe I will just hit home a couple of key points here that I think as harvest is coming up or has started in some areas, we do have a mix of scientists, technicians on the call, other industry personnel. Some are breeders, some are those conducting research trials. And for those conducting research trials, really I want to emphasize that seed that is harvested from your plots, it cannot be used for any purpose that involves planting. So as you harvest those plots, you're going to, of course, take your samples, do your quality analysis on it, your 1,000 kernel weight, your any dockage, moisture kind of measurements that need to be done. But after that is finished, the unused seed and the harvested grain must be disposed of. It can be fed to livestock, and the other option is to deliver it to an elevator or sold as grain for the class. You could bulk together all the CWRS varieties from that trial and sell that for grain at an elevator, but this cannot be planted for any purpose. So I just wanted to make sure that's clear, and that if anyone on the call has any questions, myself or Lauren would be very happy to answer them. And if you have, I know Lauren said that he's happy to talk to anyone if these kind of things come up. Myself as well, if you have any questions, and if I don't know the answers, I will be knocking on the doors of people who do know the answers, and we will make sure that this is all handled, because we do want to do our best to comply with all these all of this legislation, and stay out of trouble, because there's enough work with plots that doesn't require legal concerns on top of that. So any questions? I don't see any in the chat box. Or sorry, not in the chat box, but in the Q&A box. I should mention that we did record this webinar, and it will be posted on, maybe Megan even could comment on exactly maybe some timelines around when this will be posted. I think that might be helpful, because feel free to share this with others in your organization.
Yes, so this will be posted, Sherry. We'll probably get this up by the end of today. So I can send out that link, and then everyone that registered, I can send you guys an email with that that link for the YouTube video as well.
Fantastic. So any last chance for questions? And if you don't want to ask a question here, certainly you guys know how to reach me, and we can set you up with answers. Okay, well, with that, I will thank Lauren for presenting, Megan for arranging all the logistics of this, and everyone who did attend. Really appreciate that. And I wish you all a safe and good harvest, even if the yields are not quite what people are hoping for. So good luck through that season. Thank you, everyone.
Thank you.